I'm an optimist, Judge. I think things are going to be better in 30 days. And I'm healthy in answer to your question.
Well, I haven't. You look great, Mr. Terry. State of Nevada versus William Errico. Case number C, 307611. Counsel, please note your appearances for the record.
Morning, Your Honor. William Terry appearing. I represent Mr. Errico in the criminal matter.
Okay. Anybody else?
Good morning. Good morning, Your Honor. Jackie Nichols here on behalf of Real Party Interests at Las Vegas Metropolitan Police Department.
Okay. Is that it?
Good morning, J.P. Raman on behalf of the state.
All right. And you're in the criminal case, and are you representing the state in this matter too?
No, I believe that Marky and Arbach is going to do the majority of the arguing.
Okay. All right, we're on for Real Party and Interest Las Vegas Metropolitan Police Department's motion requiring defendant to comply with NRS 174. I looked at the motion and then the opposition. I want to make sure that I'm sort of on the same page here. Seems that there were 3 requests made by the defendant. 1 for all contact reports, write-ups by supervisors, statements of performance that mention Detectives James Downing or Cone Haynes, whether either officer's ever been listed on a Brady list for withholding evidence. Request 2, a copy of all reports, records, communications involving Angela Smalley, wherein she was suspected of committing any crime. Smalley was charged previously with committing trespassing and financial crime. Request 4, all communication document, text messages, emails, phone records between State Bar, District Attorney, and LVMPD and or witnesses of the state between 2010 and the date the request is filed. Now, looking at defense response or opposition, it seems to me that they say as to that first request relating to essentially officers' personnel files that they weren't moving forward with that at this time because LVMPD indicated those were confidential records, and to the degree any of that would have to be provided, would be provided through the prosecutor's office. I generally agree with that. Looking at that, I don't think that falls within the public record domain. It may fall within Brady or some other aspect of criminal discovery, but I don't think it falls within public record. The second thing is that as to Angela Smalley, apparently she has some additional new cases open, and so the request was modified to just concern closed cases. And then we still have the issue relating to communications between LVMPD and different agencies. I mean, am I right? Is there something else that's at issue here beyond what I've just sort of expressed?
There is on our behalf, Your Honor, William Terry.
What's that?
That we're in the wrong forum. Matter should not even been brought in front of this court. And I'd like to address that for starters.
Well, I don't see that really in your opposition.
Judge, it's interesting. This matter was never served on Miss Wilder. This was Miss Wilder's request for public information. It started about 2 months ago when the, quote, Real Party and Interest filed their documents. They didn't even serve her. We had to notify her of this document because, quite frankly, this is not a motion that is part of the criminal case. We object to the fact that the moving party is using the criminal case to bring this before the court. This should be under NRS 239. It should not be in the criminal court. Mr. Raman hasn't filed the response. Mr. Raman is not a participant to this. So I'm taking the position that with great respect to the court, you don't even have jurisdiction. I'm prepared to argue that. Jurisdiction can be raised at any point in time. I'm raising it now. Let Ms. Wilder...
If the position is jurisdiction, I'm not arguing with you that jurisdiction can be raised at any point in time. So I just wish it wasn't raised right at this second in the hearing, because it doesn't really give me much of an opportunity to take a look at your arguments. But I certainly agree with you that they can be raised at any point in time. So you got it. Let's go ahead, and you can raise the jurisdictional argument with any citations that you want to make.
Judge, I want to note for the record, I was served this motion, but I'm not a party to this matter. The motion is captioned to make us comply with the provisions of NRS 174. That's between Mr. Raman and myself. We filed the Brady motions. I believe we've gotten the discovery that we need for the criminal trial. All right? What Ms. Wilder is attempting to do is get something independent. It's no different than if the Errico criminal case was done and over, Ms. Wilder would still have the right to request these documents. And I want to bring to the court's attention that exclusive jurisdiction is under NRS 239. We start with 239.001, which indicates what the legislative intent is, and the legislative intent is to make these documents available. But if you look at 239.0107, it provides remedies. Court's indulgence.
Sure.
It provides the remedies. It says not later than the end of the 5th business day, Metro has to respond, okay? But then look at paragraph 1, parentheses, small d, close parentheses. If the governmental entity must deny the person's request because the public book, etc., is confidential, they have to provide that in writing. So there's a solution, a remedy under NRS 239. If you look at 239.011, it talks about terms of if there's a request for inspection, copying, which is exactly what Ms. Wilder has done, okay? Then notice that it says the court shall give this matter priority over other civil matters. This has to be a document filed in a civil matter once there's a final dispute. That hasn't occurred. And then you look at 239.0113, it talks about who has the burden. The state has, not the state as in the state of Nevada for the criminal case, but what's being captioned as the real party in interest. And then finally, if you look at NRS 239.0115, it talks about applying to the court for an order allowing inspection. That hasn't been done yet, okay? It hasn't been necessary on Ms. Wilder's part. We have a copy of an email that Ms. Wilder sent us. I'm not a party to that email, where Metro indicates very recently that they're attempting to comply with certain of the requests by Ms. Wilder. So my initial question is, why is this case under the criminal case number? Why wasn't Ms. Wilder served? And what are we doing in this court, respectfully? Jurisdiction is in a separate matter. Ms. Wilder can file a motion. She can file a petition. LVMPD can file their own petition. It is not part of the criminal case. I noticed that we're here on your civil calendar, but we're using the criminal case number. And again, Mr. Raman hasn't responded to this. I haven't responded to this. It does not involve the criminal case. It's an independent procedure.
I guess what sort of would throw me and maybe others off is, if you look at her opposition, she talks in terms of essentially needing evidence to raise defenses to Mr. Errico's criminal case. So, it does look, if you're reading through the document, that she's filing this public record request for the purpose of obtaining discovery for use in his defenses in the criminal case. And even at one point in time, she invites the court to deal with this matter not under the public records law, but to deal with the matter under the discovery law and intercede and force the state to make the disclosures that she's asking for. So are you telling me that this is not a cooperative effort between you and Ms. Wilder to obtain evidence for Mr. Errico's defense?
It is not, okay? And that's why I called it a separate matter. The trial date is set far down the road at this point in time. I know Ms. Wilder indicates it would be helpful to get this information for the evidentiary hearing that's set for Friday, but my position is Mr. Raman has provided me with everything that I need in order to defend this case. We have one last thing to do, and that's the evidentiary hearing, okay? Now, because it's an independent action, as I said before, Ms. Wilder could have filed this 3 years ago. She could file it after conviction. She can file it after acquittal. There's no difference here between a media request asking for public records of the LBMPD. Now, Ms. Wilder certainly wishes to assist me in the representation of Mr. Errico. More power to her. Whatever she gets, I would appreciate. But this is not my motion. This is not my public records documentation. Even if the court says that certain of the records which Ms. Wilder is seeking would be of assistance in the criminal case, that isn't my primary concern at this point in time. More power to her, I say, but this is not a joint effort. That's why she responded to this motion. I did not, but I'm raising the jurisdiction because I'm concerned that this is becoming part of the criminal case, which it shouldn't be, because of NRS 239 at SEC.
Okay, and are you opposing that?
Counsel, your appearances for the record.
The court has a few comments before we begin.
We are on the record in the matter, case D 505.
You guys either agree or I order.
I don't hear anyone saying she can't order a change of custody if she follows the right procedure.
There must be an evaluation of the best interest.
You're going to convince me to hold your client in contempt.
All right, well, Miss Wilder isn't on the line, and maybe I guess
I spoke to Miss Wilder, Judge. She could not be here today. This was done on an order shortening time. She had a prior commitment.
I understand, but I guess Miss Wilder, in her conversations or emails with my clerk, seemed to indicate that you were going to fill in for her for purposes of this motion. You're telling me you're not filling in for her for this motion or her request.
Here's what I'm prepared to do. I am not arguing her response. I think that would be inconsistent with the position I'm taking.
I agree with that.
On behalf of Ms. Wilder, I have no argument to make in reference to her response and no argument to make in reference to what the, quote, real party in interest, which I don't accept, incidentally, has filed.
Let me stop you a second, Mr. Terry. So you're telling me none of this, what we're dealing with here, is relevant for the hearing that we have set on Friday?
Well, it would be nice if I had the documents that Ms. Wilder is asking, but if the court is saying, are we prepared to proceed on Friday, the answer is yes.
All right. Let me just, as to the LVMPD attorney, is it Nichols? I'm sorry.
Yes, Your Honor.
Okay. All right. Based upon what I'm being told here, I mean, I've got a motion that's that you filed that really the real party in interest apparently appears to be Miss Wilder, who was not able to make it today, and I guess I misunderstood what Mr. Terry from her, or who knows what. At this point, it's a little confusing to me. The reason I said it today, your motion, was because I assumed this was all in relation to the hearing that we had set on Friday. It appears that it isn't relevant to that, and that can go forward. So what I'm going to do at this point is continue this matter 1 week so that we've got Ms. Wilder here, and everyone can prepare for the argument relating to Mr. Terry's argument relating to jurisdiction. Let me hear if that's okay by you, Ms. Nichols.
That's fine, Your Honor.
All right. Mr. Raman, I'm not sure what position you have in this, or what dog you have in this fight here today, but is there anything you want to put in on the record?
Yes, Your Honor. I believe I'm aware that Ms. Wilder filed this. I clearly didn't respond because it was being addressed and initially served on LVMPD as far as the public records request. But my concerns, and obviously the state has a larger and broader concern for the state of the case, is Mrs. Wilder's role in the entirety of the action against Mr. Errico. As Your Honor stated, she is making representations about certain things as far as relation to the criminal case, and I would be concerned from everybody's perspective if she's basically forcing her way into this case as co-counsel for Mr. Errico. I believe she's Mr. Errico's daughter. Mr. Terry can correct me if I'm wrong, but she's previously shown up at when we argued 7 or 8 motions back in March. She was quite involved in matters. She may have written some things, but I would be concerned with as litigious as Mr. Errico is, if and when he is convicted, whether her involvement in this case is going to extremely complicate any claims for ineffective assistance of counsel, which is, a very common thing a convicted defendant would raise. So her position in the case and her interference or her assistance needs to be clarified, because she could be doing some very serious things in a very serious criminal matter. And that's what the state is concerned about.
All right. Well, I appreciate but, Mr. Terry is Mr. Errico's attorney. He's indicating that she does not represent Mr. Errico. She certainly has a right to be present at any hearings. She certainly has a right to give Mr. Terry any thoughts that she has on this matter. And she may have, and as a member of the public, a right to make a records request to Metro. As far as ineffective assistance of counsel, I think Mr. Terry, I have absolutely no doubt, will be as effective as anyone could possibly be. So we'll kick this for a week. Give me a chance to take a look at the jurisdiction issue that Mr. Terry has brought up. I invite you, Ms. Nichols, to do the same, and we'll sort of try to define what Ms. Wilder's role is, at least from her perspective. I'm getting from Mr. Terry, and correct me if I'm wrong, that she is not a part of the legal team and is not acting on your behalf of Mr. Errico in the criminal matter.
That is accurate, but Mr. Raman is also accurate, Judge, in that she has been at every court appearance. She is, in fact, Mr. Errico's daughter. Her name is Wilder because she got married. So,
well, I figured that, but
like any daughter would be concerned about their father.
Mr. Terry, I think I said that she has a right to be present at a hearing. She doesn't even need to be a daughter. She's can be a member of the public who's interested in the case. She can be a victim. She has a right to be present in the hearings, and if you want to talk to her, you certainly have a right to talk to her. No, that's not an issue as far as I can see, at least at this point in time. All right, we'll continue the matter until next Wednesday. Do you need to make an announcement?
Yeah, it'll be September 2nd at 9 a.m.
And that will be by way of the video again, Your Honor, email or what have you?
Yeah, well, I mean, everyone right now, everyone is encouraged to appear by Blue Jeans, but if anyone wants to make a personal appearance, I'm not stopping anyone from coming into my courtroom and making a personal appearance.
Very well, Judge. May I address the court on one other matter?
I guess so.
Judge, we're set for the evidentiary hearing on Friday. We're prepared to proceed, but I do want the court to know that I sent Mr. Raman hard copies of our exhibits, as I did to the court. And likewise, Mr. Raman sent me a link to his exhibits. He likewise sent me a request to see if I would stipulate to those. And in all candor, I've told him I haven't even looked at them yet because, I've been more concerned with this appearance today as opposed to the Friday's appearance. So that's the status.
Take a look and see if obviously I'd like this to go quicker rather than longer. On Friday, take a look at those. I mean, technically, Mr. Terry, I think we aren't supposed to be accepting hard copies here in the courthouse. If you've got that at all on electronically, it may be better. Are you going to appear here personally on Friday, or are you going to appear over Blue Jeans?
Judge, the directive I received is I should be here on Blue Jeans. Now, if the court changes that, I'm happy to appear. I think it's always better if I'm in court, to tell you the truth.
Well, I'm not going to disagree. We're trying to minimize people coming to the courthouse. Obviously, the more people that come, the greater the issue of exposure with the pandemic. I have not told people that want to come that they can't come. So, we are encouraging people to appear by Blue Jeans. We encourage the witnesses to appear by Blue Jeans. But if you want to come down here, if you're feeling healthy, haven't been around anyone with COVID-19, and you wear a mask, I have no problem if you show up in court to handle your side of the case.
Thank you, Judge. How do you want us to handle the exhibits? Because I think the state's going to call witnesses. we're going to be showing them, quote, exhibits, close quote. I'm sure the state will do the same thing.
Well, if you use Blue Jeans, then my clerk can send you an email explaining how you can make the exhibits appear on Blue Jeans. And if you send us a digitalized Blue Jeans, digitalization of the exhibits, my clerk can keep the records as to what's emitted or what's not emitted. If you appear here in court, we'll have the overhead projector that you can use to put up on the screen. My clerk won't accept your hard copy, but will note, based upon your electric digitalized copy of the records, that what's emitted and what's not emitted. But she can't accept a hard copy at this point in time. I don't mind if you want to give me a hard copy. I'm not as concerned, I guess, about my health as the clerk's office is about their employees' health, and I'm glad that they are concerned about their employees' health. I'm willing to take that, but she absolutely can't take a hard copy from you.
Very well, Your Honor.
The ELMO can only work if all parties are in person. If we have split appearances, it's not going to work for the people on Blue Jeans.
Oh, okay.
So either all parties are on Blue Jeans or all parties are in person.
And Your Honor, J.P. Raman for the state. I'm going to be in talks with your clerk because I do have one witness who will appear via Blue Jeans because he's in Utah. I had anticipated having one witness appear physically in court. I had planned on being there physically in court, but I need to talk to your court recorder to make sure that functionally what I'm trying to accomplish with exhibits and witness testimony is actually going to work. So, I mean, maybe we'll have to default to Blue Jeans to make the exhibits work. I'll have further discussions today about that.
Well, I mean, we can make if people are here present, we can bring in the witness by Blue Jeans, right?
Yeah, but if you want to display whatever's on the ELMO, it's not going to work.
And respectfully, if we're going to have a witness on Blue Jeans, I'm going to object to that procedure, Judge, for the exact reason your clerk just indicated.
Well, we're allowing witnesses to appear remotely, and there is precedent in the Supreme Court rule that allows it. I'm going to allow witnesses to appear remotely if they don't want to be here, and so I'll overrule that objection at this point in time.
Very well, Judge.
So.
Court IT has told us it's either or. So all parties are either on Blue Jeans or all parties are either in person.
Well, if they're in person, can we use Blue Jeans from here? Well, if the witness is not here, but I mean, if the attorneys are here, can they use computers to broadcast it to?
No, it's going to turn off the Blue Jeans.
Not asking as a motion, but would the court inquire of Mr. Raman and then the court a suggestion to move this hearing date?
Well, I'm not sure moving it is going to solve any tremendous problem, any problem. I mean, I have a feeling we're going to be COVID Blue Jeans issues for the rest of the year until there's either an effective treatment or a vaccine. I have a suspicion that we are going to be encouraging Blue Jeans during the course of. Not that I'm excited about it either, Mr. Terry, but I'm just telling you the reality here.
I understand, Judge. And again, we don't have a trial date till the end of January. It's not like this has to be done Friday. But I know Mr. Raman has always been insistent on moving it along. The court has done that too. But the reality of life is it's very difficult when, as we've just discussed, one witness is on Blue Jeans and we're dealing with exhibits. I'm an optimist, Judge. I think things are going to be better in 30 days. And I'm healthy in answer to your question.
Well, I haven't. You look great, Mr. Terry. You know, I hope you're right about things being better in 30 days. I don't want to spend really much more time on this. I mean, if you want to, I don't know, Mr. Raman, what's your position as to Mr. Terry's request?
Your Honor, I'd like to get this hearing done on Friday. We've already postponed it previously due to COVID.
Okay, that's all right. We're gonna keep it on Friday. Let's see what we can get done.
I can run a test run on their exhibits if they all want to appear on Blue Jeans before Friday.
Okay. If you want to if you want to appear by Blue Jeans and do a test run on exhibits, contact Angie. Is there a number they should call you at?
Yes, it's 671.
671. And we'll see. We'll make this work one way or another on Friday.
Very well, Your Honor.
All righty.
Thank you.
All right, thank you, Your Honor.